Okay, good evening, class. Here we are again. We will discuss the fifth PowerPoint presentation for the semifinal coverage. And our topic for tonight is Data Privacy Act, continuation of a previous slide. And of course, before we proceed with our lecture, we would like to credit the following acknowledgement to these researchers. Number one, Kate Princess Miss Pahe, Princess Kate, Liedo Margie B, Mester Shannon Grace, Miron T. Anwin, Morales Clive, Ochabelio Tisha May, Pactoran Honey Grace, and Pates Kate Hart. Now, as usual, we are going to give pre-test or post-test examination questions. And here are the questions, the following questions. 1. Why does Personal Information Controller comply with the Data Privacy Act? Number 2. What is the penalty for unauthorized access or intentional breach? Number 3. When is the deadline for approval or disapproval of an agency request? Then number 4, what is the applicability of government contractors in accessing sensitive personal information? Number 5, what is the requirement of a government employee to access sensitive personal information on government property? Number 6, what is the responsibility of heads of agencies? Number 7, what is the penalty for a combination or series of acts? Number 8, what are the additional penalties if the offender is a public official or employee? Number 9, what is the principle of accountability? And number 10, what is the penalty for concealment of security breaches involving sensitive personal information? Now, class, let's going to answer the questions that we gave. Okay. Number 1 question, why does Personal Information Controller comply with the Data Privacy Act? Answer, the Personal Information Controller must comply with the Data Privacy Act and utilize contractual or other reasonable procedures to protect information processed by a third party. Number 2, what is the penalty for unauthorized access or intentional breach? The answer is, any person who illegally breaks into a system containing personal and sensitive data is 1 to 3 years in prison and 500,000 to 2,000 fine. Then number 3, when is the deadline for approval or disapproval of an agency request? Answer, any request submitted to an agency head must be approved or denied within 2 business days. Number 4, what is the applicability to government contractors in accessing sensitive personal information? Answer, an agency shall require a contractor and its employees to register their personal information processing system with the Commission in accordance with the Data Privacy Act before entering into any contract that may involve accessing or requiring sensitive personal information from 1,000 or more individuals. 5. What is the requirement of a government employee to access sensitive personal information on government property? Answer, except as allowed by Commission guidelines, no government employee shall have online access to sensitive personal information on government property without a security clearance from the head of the source agency. Number 6 question, what is the responsibility of heads of agencies? The answer, the government, its heads, its agencies and instrumentalities shall secure sensitive personal information using the most appropriate standard recommended by the information and communication technology industry and approved by the Commission. Number 6, what is the penalty for a combination or series of acts in violation of the Data Privacy Act? Answer, any combination or series of acts shall be made shall make the person subject to imprisonment of 3 to 6 years and a fine of 1,000 to 5,000 pesos. Number 8 question. What are the additional penalties if the offender is a public official or employee? Answer. If the offender is a public official or employee and he or she is found guilty of improper disposal of personal information and sensitive personal information and processing of personal information and sensitive personal information for unauthorized persons, he or she shall, in addition to the penalties prescribed, suffer perpetual or temporary absolute disqualification from office as the case may be. Number 9. What is the principle of accountability? Personal information are within the controller's control or custody, including personal information provided to a third party for processing, is liable. Personal information controllers are responsible for all personal data under their control, including the data sent to third parties for processing. And last question is, what is the penalty for concealment of security breaches which involves sensitive personal information? The answer, any person who, after having knowledge of a security breach and of the obligation to notify the Commission, intends to as discussed further. Accountability for transfer of personal information. Principle of accountability. Personal information within a controller's control or custody, including information provided to a third party for processing, is the liability of the person accessing the same or storing the same. Now, personal information controllers are responsible for all the personal data under their control, including data sent to third parties for processing. Number 1, the Personal Information Controller must comply with the Data Privacy Act and utilize contractual or other reasonable procedures to protect information processed by a third party. Number 2, Data Protection Officer. The Personal Information Controller must appoint a Data Privacy Act officer, and the data subjects can seek the names of selected individuals. Security sensitive personal information in the government. The responsibility of heads of agencies. As far as possible, the government, its agencies, and instrumentalities shall secure sensitive personal information using the most appropriate standard recognized by the information and communication technology industry and approved by the Commission. Now, requirements relating to access by agency personnel to sensitive personal information. 1. On-site and online access except as allowed by the Commission guidelines. No government employee shall have online access to sensitive personal information on government property without a security clearance from the head of source agency. What about the off-site access? Unless otherwise noted in the Commission guidelines, sensitive personal information maintained by an agency may not be carried or accessed from a location of government property unless the agency heads makes and authorizes a request. A. Deadline for approval or disapproval of any request. Any request submitted to an agency head must be approved or denied within 2 business days. In this case, there is no action by the head of the agency, then such request is considered disapproved. B. Limitation to 1,000 records. If a request is approved, the head of the agency shall limit the access to not more than 1,000 records at a time. And C. Encryption. This part requires that the use of Commission's highest secure encryption standard to store, transport, or access sensitive personal information for off-site access. Now, applicability to government contractors. An agency shall require a contractor and its employees to register their personal information processing system with the Commission in accordance with the Data Privacy Act before entering into any contract that may involve accessing or requiring sensitive personal information from 1,000 or more individuals. Unlawful acts and penalties. 1. Unauthorized processing. Any person who processes personal information without the consent of the data subject or without being authorized under the Data Privacy Act or any existing law, these are the penalties. For personal information, the imprisonment is 1 to 3 years and the fine is 500,000 to 2 million. For sensitive personal information, the imprisonment penalty is 3 to 6 years and a fine is 500,000 to 4 million pesos. Now, as to access, anyone who negligently provided personal information without utilization or authorization from the Data Privacy Act or other law, the penalties are the following. For personal information, imprisonment is 1 to 3 years and a fine of 500,000 to 2 million pesos. In sensitive personal information, 3 to 6 years and a fine of 500,000 to 4 million pesos. What about improper disposal of any information? Any person who deliberately or negligently disposes, discards, or abandons an individual's personal information in a public location or in its trash container, the following are the penalties. For personal information, imprisonment from 6 months to 2 years and a fine of 100,000 to 500,000 pesos. For sensitive personal information, imprisonment is 1 to 3 years and a fine of 100,000 to 1 million pesos. Now, for processing of unauthorized purpose. Now, processing personal data without consent or authorization under this act or existing laws, the following are the penalties. Now, unauthorized processing of personal information, the imprisonment is 1 year to 6 years, 6 months, 1 year and 6 months to 5 years, and a fine of 500,000 to 1 million. Now, processing unauthorized for unauthorized purpose, sensitive personal information, imprisonment from 2 to 7 years, while a fine of 500,000 to 2 million pesos. Now, unauthorized access or intentional breach, any person who illegally breaks into a system containing personal and sensitive data, the penalty is 1 to 3 years in prison and 500,000 to 2 million fine. Now, concealment of security breaches involving sensitive personal information. Any person who, after having knowledge of a security breach and of the obligation to notify the Commission, intentionally or by omission conceals the fact of such security breach, then the penalty shall be imprisonment of 1 year and 6 months to 5 years and a fine of 500,000 pesos to 1 million pesos. What about malicious disclosure? Number 7, any personal information controller or personal information processor or any of its officials, employees, or agents who, with malice or in bad faith, discloses unwarranted or false information relative to any information or personal sensitive information obtained by him or her, the penalty shall be imprisonment of 1 year and 6 months to 5 years and a fine of 500,000 to 1 million. Now, unauthorized disclosure, any personal information controller or personal information processor or its officials or agent who discloses to a third party personal or sensitive personal information not covered by malicious disclosure above without the consent of the above subject, the penalties are the following. For personal information, imprisonment 1 year to 3 years or a fine of 500,000 to 1 million. For sensitive personal information, there will be imprisonment of 3 to 5 years to a fine of 500,000 to 2 million pesos. Now, it shall be subject to imprisonment ranging from 1 year to 3 years and a fine of not less than 500,000 but not more than 1 million. Now, combination or series of acts. Any combination or series of acts as defined in the above shall make the person subject to imprisonment 3 to 6 years and a fine of 1 million pesos. Extent of liability. The juridical person, if the offender is a corporation, partnership, or any juridical person, the penalty shall be imposed upon the responsible officers, as the case may be, who participated in or by their gross negligence allowed the commission of the crime. If the offender is a juridical person, the court may suspend or revoke any of his rights under Data Privacy Act. And if it's an alien, if the offender is an alien, he or she shall, in addition to the penalties above, be deported without further proceedings after serving the penalties prescribed. Large scale. The maximum penalty in the large scale of penalties respectively provided shall be imposed when the personal information of at least 100 persons is harmed, affected, or involved as a result of the above-mentioned actions. Number 4, public official or employee. If the offender is a public official or employee and he or she is found guilty of improper disposal of personal information and sensitive personal information and processing of personal information and sensitive personal information for unauthorized persons, he or she shall, in addition to penalties prescribed, shall suffer perpetual or temporary absolute disqualification from office as the case may be. Now, offenses committed by public officers. When the offender or the person responsible for the offense is a public officer as defined in the Administrative Code of the Philippines in the exercise of his or her duties, an accessory penalty consisting in the disqualification to occupy public office for a term double the term of criminal penalty imposed shall be applied. Now, is there restitution? Yes, restitution for any agreed party shall be governed by the provisions of the new Civil Code. Now, since that is the end of our lecture, we thank you for hearing it out. Thank you for listening, and I hope you have remembered these lectures because that will be part of our exam for the midterm, for the semifinals. So thank you and good evening, class.